Picture this. You're in Superior Court downtown. A bailiff calls your name, your heart's racing, and all you can think is, am I going to jail today? Now, let me stop right there. In Arizona, an arraignment is like airline boarding. You can't take off until everyone's scanned in, seatbelts are checked, and the captain confirms the manifest. Boring? Usually. Essential? Always. I'm going to walk you through every step, but bust a few myths. I'm going to walk you through every step, bust a few myths, and share two quick client stories that prove why staying calm here saves headaches later. I'm Joel Chorny, criminal defense attorney in Tucson, Arizona, and this video is for legal information, not bespoke advice. Every case is unique, and if you're staring at an arraignment, call your own lawyer, or call my office and we'll help you out. Back in 1215, when the Magna Carta became a thing, English barons forced King John to agree that no one could be held without lawful judgment of his peers. Fast forward 800 years, and Arizona has codified the same idea in Rule 14 of the Rules of Criminal Procedure. So, the job of the arraignment is to 1. Tell you the charge, 2. Advise you of your rights, 3. Enter a plea, and 4. Set the roadmap forward. That's it. There are no evidence battles, no jury, no more. It's more like a motor vehicle division window than a Law and Order episode. Arizona uses two clocks, 10 days if you're in custody and 30 days if you were released or received a summons. Judges take those clocks seriously. What this means is that you need to have your arraignment in that time. And if the deadline is missed, the case can be dismissed or the defendant's release conditions can flip. Think of it as a get on the calendar guarantee. Now, let's talk about what exactly happens at the arraignment here in Arizona. 1. The case is called. First, the bailiff or clerk calls the case. You'll hear something like State of Arizona versus Smith, case number CR 2025-12345. That's your cue to approach the podium with your lawyer. 2. Identity check. The judge confirms you are who you are. They'll ask, please state your name and the date of birth for the record. You say both clearly and you keep it short. No extra commentary. 3. Reading the charge. The charge is read out loud. The clerk might read the entire indictment, but most defense lawyers, we waive the reading to save time and to save the embarrassment. We don't need the whole world hearing what our clients are charged with. Either way, the law is satisfied and you're officially notified. 4 is the rights recap. The judge reminds you of your core 4 rights: the right to the presumption of innocence, the right to counsel, the right to remain silent, and the right to a trial by jury. It sounds routine, but these words anchor the entire criminal system. So listen, even if you've heard them before. And 5, your attorney status. The court's going to ask about counsel. If you've already hired me or any private lawyer, I or that lawyer will announce Joel Chorny on behalf of the defendant. If you don't have a lawyer and you can't afford one, the judge will appoint counsel right then and there, usually someone from the public defender's office. The 6th step is the plea entry. 99%, if not more, of cases enter a not guilty plea. A guilty plea ends the case. It ends the proceedings, and that's why you don't usually enter it at that point. In fact, if you try to, chances are the judge is going to say, talk to your lawyer, because that short circuits the whole process. A quick tip: if nerves make you blurt guilty, like I said previously, most Arizona judges will protect you from yourself. They'll enter a not guilty and say, speak to your counsel first. That's Rule 14.4 at work. So don't be worried if you say something you don't mean to. The judges know what's supposed to happen at the arraignment. It's not a whole lot of controversy. Step 7. Your release conditions review. The judge will decide whether you're going to have a bail, if you're going to be released on your own promise to come back to court, or if pretrial services are going to need to be supervising you with things like drug testing and ankle monitors and things like that. Let me share a short story. I once had a client whose only condition was no contact with Walmart. He leaned into the mic, dead serious, and asked, Your Honor, am I allowed to shop at Target? Now, of course, everyone in the courtroom chuckled, and the judge said that Target was fine. So the moral of that story is that the conditions can be quirky, but they also can be negotiated to some extent. Step 8, setting the next dates. The judge is going to set the roadmap. An initial pretrial conference or case management conference, which is usually 30 to 45 days out. And then the judge will also assign your trial judge, who is unlikely to be the same judge who presided over your arraignment. Now, that date is mission critical. If you miss it, you risk a bench warrant being issued against you. So you don't want to miss those court dates. Step 9, the paperwork and exit. You'll sign a release order and receive a printed sheet with your next court date. Treat it like a boarding pass. Snap a photo, add it to your calendar, and do not lose it. You are now officially arraigned. And now that's every moving part. No surprise witnesses, no TV-style objections, just a mandatory checklist that launches your case down the track. Imagine Netflix buffering. The arraignment is the initial 10% download. The story can't play until that buffer completes. That's what this is. Now, let me share two stories with you about clients. First story that I'm going to call the relieved first timer. Marisol, not her real name, but a 19-year-old U of A student, was terrified that she'd go to prison for shoplifting a $45 shirt. The arraignment lasted all of 4 minutes. The judge entered a not guilty, released her, scheduled diversion, and she later told me that the scariest part was the wait in line for security. But I want you to contrast Marisol's story with the story of Tony, also not his real name, an overconfident veteran. Tony was a repeat DUI client who showed up in shorts and mirrored sunglasses. The judge scolded him for the disrespect and almost revoked his release. It was the same routine hearing, but the attitude made a huge difference. Courtrooms are still formal spaces. Be aware of that. Now, I want to talk a bit about common misconceptions versus reality of arraignments. Let's bust 5 myths that I hear every week about arraignments in Arizona. I'll give you the myth first and then the reality. Myth number 1, the judge decides if I'm guilty at arraignment, and that's just not true. The reality is that the job is administrative for the judge. They record your plea, they set future dates, and they make sure that the process is constitutional. Questions of guilt and innocence come months later in plea negotiations or at trial. Myth number 2, I need to say a lot to defend myself. The reality is that you only confirm your name and your date of birth. Your lawyer handles every substantive issue. Less is more. Silence is safety. Myth number 3, we're going to argue evidence today. No, the evidence fights start after arraignment. The clock for disclosure, when the police reports, body cam, lab results, etc. are going to get sent over from the state. That begins once the not guilty plea is entered at the arraignment. Myth 4, if my lawyer shows up, I can skip court. Not in Arizona. Unless the judge explicitly excuses you in advance, your personal appearance is mandatory, as long as we're talking about felony court. In many lower courts, misdemeanor courts, the truth is that you can have your lawyer show up instead of you. But if we're talking about arraignments, the kind of arraignments that I've been describing in this video, we're talking about felony arraignments, and you are going to need to come to court for those felony cases unless the judge has previously given you permission to miss court, or an emergency arises that the judge is going to find warrants your absence. But if you miss your court date, you risk an immediate bench warrant. So be in communication with your lawyer and make sure that you're calendaring your dates. Myth 5, public defenders are just public pretenders. This myth is one that really gets to me, bothers me, because it's so not true. The reality is that public defenders take the same bar exam that I did. They follow the same ethical rules, and they appear before the same judges. Show them respect. They fight hard with limited resources. The bottom line is that arraignments are procedural, not dramatic. Knowing these truths keeps the days short, your stress levels low, and your rights intact. Now, when deciding release conditions, Arizona uses a risk assessment tool that looks at your prior failures to appear, the seriousness of the offense, your ties to the community. At the arraignment, the judge can continue your previous conditions of release, modify those conditions of release, which could include adding an ankle monitor, for example, impose bail, or they can remand you into custody if they have found out about a new violation. So you want to bring proof of address and employment, pay stubs, or lease, something that shows stability, as that will help lower bail and help allay the concern that for the judge that you're not going to show up to court like you're supposed to. A point about remote appearances or video arraignments. Especially after COVID, this is more of a thing. Many Arizona counties kept Zoom arraignments for low-level felonies and misdemeanors. You still stand virtually when the judge enters. The dress code still matters. You don't want to be caught wearing pajamas. The background noise can irritate the judges, so you want to use headphones. And the link will arrive by email. You want to log in 10 minutes early for the virtual meeting room just to make sure that you're not late and no one's waiting for you to show up in the virtual meeting room. Now, I want to talk about a few practical checklists, takeaways, things that will help you prepare for your arraignment. 1, you want to calendar the next hearing before you leave the building. Don't leave it for later. You might forget. Ask for a copy of the complaint. Read it. Highlight surprises. You want to retain or meet your court-appointed counsel as soon as possible. They should start requesting evidence and working on your case. You want to stay off of social media about your case. The prosecutors screenshot everything. I have another video on this. You would be surprised at how easy it is to screw up a case with social media. And remember, the arraignment is routine. The chess match hasn't even begun at that point. Now, if you're staring down an arraignment in Pima, Maricopa, or anywhere else in Arizona, breathe. It's formal, but it's step 1. And with the right strategy, you'll control what happens next. I'm Chorny. Remember, your rights matter, protect them, stay safe, and I'll see you in the next video.